Everyone, welcome back to our channel. Now we are discussing on nominee rights in shares under Companies Act versus succession under Indian Succession Act. We are discussing on Supreme Court's landmark judgment. So the background of the case. This is the landmark judgment by Honorable Supreme Court in case of Shakti Yezdani and another versus Jayanand Jayant. This case revolved around the one critical legal question. Does a nominee become absolute owner of the company shares? Or do the legal heirs retain inheritance right under succession law? This is the question. Legal question. Does a nominee become the absolute owner of the company shares? Or do the legal heirs retain inheritance rights under the succession law? So let's deep dive into the background and key provisions and court's detail reasoning. See, the deceased Mr. Jayant Salgaonkar passed away on 20th August 2013. He had executed a will dated 27 June 2011, distributing his assets. So, will was there, deceased passed away on 20th August 2013. He has fixed deposits worth 4.14 crores, mutual fund investments 3.79 crore, where nominees were appointed. Legal heirs contested the nominee's right, leading to civil litigation. So the legal provisions in question is Companies Act 1956 provision. That time it was 109A of Companies Act 1956, and that allows a shareholder to nominate a person to whom the shares shall vest upon the death of the holder. So the bylaw of the Depositories Act 1996 contains similar language regarding nomination and vesting. Non-obstant clause, the provisions include non-obstant clause, notwithstanding anything contained in any other law. So giving them overriding effect. So the issue is, does this clause give a nominee ownership rights to the exclusion of legal heirs? Conflicting views. Previous case laws, if you see, Sarvati Devi versus Musa Devi 1984 held that nomination does not confer ownership. Legal heirs under succession law prevail. This was the judgment in 1984 in Sarvati Devi versus Usha Devi. Then in another case, Vishin N. Kanchandani versus Vidya Kanchandani, the judgment was nominee can receive the amount but cannot use it as a owner, holds it in trust for legal heirs. This was the another judgment in another case. And if you see other case, Harsha Nitin Kokate versus Saraswat Bank. Here is a different judgment, held that nominee becomes the full owner. This view created a controversy. Then if we go to another case, Arna Oswal versus Pankaj Oswal supported a literal interpretation of Section 72, but Supreme Court refrained from deciding nominees' ownership rights in that case. So the key legal issues involved is whether nomination under Section 109A of the Companies Act 1956 overrides the succession law. So that time it was 1956 Act, now 2013. So whether the term vest used in statute implies absolute ownership, whether the non-obstant clause grants nominee full legal rights, is the nomination process equivalent to statutory testament will? Can nomination lead to third line of succession? These are the questions. So Supreme Court's analysis, nomination is not ownership. Court clarified that nomination is not a will. It is meant only for facilitating corporate functioning, not to replace inheritance laws. So the interpretation of vesting. Vesting does not always mean absolute ownership. Refers to interim authority to allow the company to recognize someone for internal purposes. The judicial interpretation was relied on Fruits and Vegetable Merchant Union and Municipal Corporation versus HPCL, where vesting was held to be limited, not complete ownership. So the contextual interpretation, a statute must be read as a whole. The non-obstant clause is only to protect the companies from disputes, not to effect succession laws. Judiciary role of nominee. A nominee holds the shares in trust for legal heirs. The rights of the legal heirs under Indian Succession Act prevail. So the key observations of the court was no third mode of succession exists under Companies Act. So the intention of the nomination is to ensure continuity in company records, not to confer ownership. Nominees' rights are administrative and custodial, not beneficial. Formalities required under Section 63 of the Indian Succession Act are not fulfilled by mere nomination. Formalities required under Section 63 of the Indian Succession Act are not fulfilled by mere nomination. So the final decision of the Supreme Court was the appeal was dismissed. The court upheld the rights of the legal heirs over the nominee and clarified that nomination does not override succession law. Nomination does not override succession law. So this reaffirms the legal principle that succession law governs asset inheritance, not corporate nomination provisions. So the conclusion, the legal takeaways, nomination is for facilitating transfer of shares or securities, not for conferring ownership. Nomination do not inherit by virtue of nomination. Legal heirs must inherit as per Indian Succession Act 1925, Hindu Succession Act 1956, or other applicable personal laws. Companies Act, whether it is 1956 or 2013, does not override succession law. This judgment ensures legal clarity, corporate stability, preservation of succession rights. If you like this video, subscribe and hit the bell icon. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe so that you will not miss any of the latest updates on corporate laws and NCLT matters and public issues. Thank you.